Yes, sir.
Mr. Chairman, I have a housekeeping issue. The talented and capable Ms. Wheat informed me that I neglected to move into the record two sets of exhibits to Mr. Addison's testimony. I'd like to do that now, if I may.
Okay.
With respect to the direct testimony of Mr. Addison in dockets 207 and 305, I would like to move for admission exhibits 1A through 5A, JEA 1A through 5A, and we can either do that as exhibit 58A, if that works, because does that work, Mr. Butler?
Yes, please. Let's make them A's so we'll keep them in line in the record.
Thank you very much. So we move that set of exhibits in as 58A, and there is one exhibit, JEA1, to Mr. Addison's surrebuttal in the 207 and 305 dockets, and we would ask that JEA1 to the surrebuttal in the 207 and 305 dockets be marked as 58B.
58B it will be.
Thank you.
Thank you very much, Mr. Chairman. Thank you, Ms. Wheat.
Thank you. All right. We're ready to begin again. I apologize for mentioning my birthday. I just felt like I was about 26 when we started this. Mr. Richardson.
Thank you, Mr. Chairman. On this issue, let's go ahead and cut to the chase. Let's look at the 2015 order from this commission, hearing Exhibit 8, page 57. Now, based on SC&G's testimony to this commission and ORS's witness, who also relied on SC&G, let's look what the commission found in 2015's order approving the schedule and budget changes sought by SC&G. In supporting the settlement agreement, Mr. James testified that based on ORS's review, based on SC&G's in-depth evaluation that they testified about, and based on SC&G's adoption of the proposed schedule and budget, ORS found that the cost estimates had sufficient support to provide a reasonable basis to proceed with the units. The commission has reviewed Mr. James' testimony against the record as a whole, including the extensive testimony and evidence provided by SC&G concerning its review and analysis of the EAC cost estimates and other cost estimates, and the methodology by which SC&G claimed that they were created. And the commission found that those presented there were supported by the record. You can see here, Mr. Addison, can't you, why it's important that Mr. Burns' testimony about the review and about the analysis that SC&G did in finding that the consortium's numbers were the ones that were best it was so important to the commission's order in 2015, can't you?
I believe it was very important to the commission.
And can you also agree with me that SC&G did not disclose two material facts? One is that the results of their internal conclusion disagreed and was substantially higher than what they presented to the commission to find.
I agree with you that this team ran a different analysis based on the historical performance factors, and it was higher. I think that's implicit if he's saying that the consortium hasn't achieved these performance factors yet, that it has to be higher. And yes, I would agree that that difference is material.
It's certainly not explicit that the South Carolina Electric and Gas review that's being testified to and the basis of the commission's order, it's included conclusions that were different and that were much higher than what was being asked. The commission was being asked to approve. Isn't that right?
The analysis of that team was higher.
And wasn't disclosed to the commission. in this filing or in the testimony in 2015, was it?
That's my understanding. The company concluded that the contractor's estimates were the most proper estimates to use.
And did you?
And I said earlier, I wish we had, just so you could have, so everyone could have seen the difference. But that's benefit of 20/20 hindsight on my part.
Because they were material differences, it could have made a difference, couldn't it?
It certainly could have. I don't know if it would have or not. I just don't know.
Did you participate in any meetings to prepare Ms. Walker's 2015 commission testimony?
I did not testify in that proceeding, so I was not in all of those meetings, but I was in occasionally in the meetings. I don't remember how much.
Were you in the meeting in which her testimony was drafted and when she wasn't present?
I don't remember that.
Would you agree that it's inappropriate to have a meeting to prepare a witness's testimony without the witness even being present?
I don't know that happened. I know in my case, I agree on what the principles are to be included in the testimony, and then I don't draft my testimony, but I review it and make sure I agree with it before I testify to it here.
Is that the practice for all SC&G witnesses coming before the commission, that someone else drafts their testimony?
I can't speak for all of them. I don't know.
Do you agree that it would be inappropriate for an SC&G attorney to demand that testimony ignore the internal review and analysis that was reached a different result?
Would you repeat that, please?
Yeah, would you agree that it would be inappropriate for an SC&G attorney to demand that the testimony be changed to ignore the internal review and analysis that reached a different result than that testimony?
I think the person who's testifying needs to believe the testimony. If they don't believe it, they certainly shouldn't testify to it.
Let's go back and look at the Brown deposition where SC&G was distributing talking points about how to deal with ORS. Sure, there's two lines I think that are important that I want to know if you knew about this. It's not it. Yeah, part about we had talking points. Excuse me. Page 232. We had talking. You see that we had talking points that were developed, and I was to provide those talking points.
I see it, yes.
And then by getting those talking points, I was instructed. Where's that? By getting those talking points, you see right there, I was instructed as to what I was to tell ORS.
I see that.
And you can see the next follow-up that the belief that the consortium's EAC was not attainable was not among the talking points to be shared with ORS.
I see it there.
Did you know that filtering was going on with what was being told ORS?
No, I wasn't aware of any filtering.
Let's go. Let's move on. I referenced this shield building issue because there was a problem in July of 2015, right before the hearing in the March 12, 2015 filing. That hearing was actually on July 21, and Ms. Walker contacted you again about disclosures relating to delays in the shield building. Do you remember that?
I don't remember it specifically.
All right, let's look. This is a hearing exhibit, Walker's testimony, Walker's deposition. It's an email on July 27th, 2015. From, this is your response about she was trying to get together. And she was concerned about a new disclosure by the consortium about a shield building work that would cause a delay in the critical path. Do you remember that?
I don't remember that, no.
You remember about she said that SC&G had presented information to the commission just 5 days earlier about the modification, but didn't disclose this delay in the critical path of the project?
Is there more to the email that I could see?
See, then you followed up, said you would definitely call. Do you remember talking about the shield building delays right around the time of the hearing in this modification proceeding?
I don't. I'm sorry.
Okay. Were you aware that the consortium actually never had a fully integrated resource loaded schedule at any point in time for this project?
No, I've heard a lot of discussion about that, but I can't tell you if they did, if they didn't, or when they did or didn't.
Do you know the significance of having a fully integrated resource loaded schedule?
I apologize, but again, I'm not a construction person, so I would be off my limb, not just out on it, but off my limb.
You would have to defer to like senior engineers on the nuclear project within SC&G on matters like that, right?
I would have to defer to someone that's very knowledgeable about it.
Right. And let's look at this email on August 5th, 2014. This is, we'll have to mark this as an exhibit, please. Are you aware of the ongoing problems with the schedule, construction schedule?
Yes, we came before the commission a few times to adjust the schedule, so I was aware of it generally, yes.
And not just the fact that you had to come in and ask for extensions of the schedule with the commission, but that the construction schedule itself was part of the problems that the project was facing.
I've heard a good bit of discussion about that post-abandonment, so yes, I'm familiar with it.
And did you know that, Andrew, can I get a copy? And are you familiar with the computer network drive that CB&I would share with the with SC&G that contain the schedule?
No, I'm not familiar with that at all.
Are you familiar with the Primavera software, Andrew?
No.
Let's go ahead and identify this right now as hearing exhibit 65, so we'll know. And we'll enter it as exhibit number 65.
Thank you very much, Mr. Chairman. And you see the August 5th, 2014 letter from Bernard Heydrich. Do you know who he is?
I do not. I see it, but I don't know him.
You know Kyle Young, though, don't you?
Yes.
And both of these folks work for SC&G in the nuclear project.
I don't know. Mr. Young could address that.
And you see what his statement to Mr. Young is about the schedule. The schedule is a joke.
I see that.
And more importantly, the third, there's nothing verifiable in what they posted on the computer network drive for the schedule, RTO1.
I see that.
And then it says it's just a grouping of hammocks with long arbitrary durations, in my opinion, with no relationship to the tiers or sub-tier activities. It's not acceptable. Essentially one line logic schedule to complete with gaps, and they can show anything they want. Someone should be fired for thinking this would be acceptable. I have attached the schedule, the entire schedule. Do you know the Primavera schedule document that was shared by the consortium with SC&G?
No.
So you didn't know that your own SC&G nuclear folks didn't believe and didn't have confidence at all in the schedule?
I don't know that today. I mean, I can read what you asked me to read here, but I don't know. Sounds like one person's opinion.
Fair enough. Let's look at the next one, January 22nd, 2015. This is an email from Mr. Brown, right, senior engineer on nuclear for SC&G, to Mr. Skip Smith and Carlette Walker, who were in charge of finance for the project, right?
Right. Again, two different groups. Mr. Smith worked in Ron Jones' construction organization, and Ms. Walker worked in the finance organization.
Right. This is Mr. Brown, the senior engineer on nuclear, talking not just to finance on nuclear, but to construction as well, right?
I don't see. I mean, I don't have a document. Is there one?
Getting that passed out, and it'll be entered as hearing exhibit 66.
Thank you, Mr. Chairman. And when I say construction, Skip Smith works for Ron Jones in the construction side of the nuclear division for the project, SCNG, right?
Right.
And here he says, I just learned that the June 2019 Unit 2 substantial completion date is June 26. Even this is not real. It's based on assumption that it meets original delivery dates, which had long since passed, right? And CBEIs is able to start erection on March 24th, 2015 as a hard constraint in the schedule, which was less than 2 months later. But he says, he goes on to explain why it's important, because if you release the constraint, it pushes the start date out 3 to 4 weeks. Again, really looking at early August or July with acceleration. And all along, our manager has been told the current date is June 2019, and we want to pass this information along. You see that?
I see it.
Let's go to one more so we can move on. This is an email August 27th of 2014 from Kim Brown to Carlette Walker. We've talked earlier about the schedule on which the estimate at completion was being analyzed and reviewed, because it had to be based on some schedule. And in August of 2014, the same month you received it from the consortium, there was a question about how is the schedule going, because Ms. Walker in finance was asking Mr. Brown, senior engineer, how's the schedule work going so we can get started on the EAC review. And Mr. Brown responds to this question 9 a.m. on August 27th by saying, I don't know what wrapping up is a good description. Go over to the rest of that. He says, covering up is probably better. We have a schedule that shows completion of Unit 2 in September 2018 and Unit 3 in September 19 on paper. But we also have a long list of requirements that must be met to meet that schedule. We went through it, and we ranked and evaluated risk of what's happening and what they occur. And based on the risk as we rate them now, it's unanimous. He's speaking on behalf of the engineer, senior engineer on this project. It's unanimous that there's 100% chance we will not meet the September dates. We do have a conceivable path to, quote, success, end quote, and a list of challenges to address to make that possible. And we have all believed all along that the shield building is the #1 challenge list, right? That is part of the critical path. And if you go to what we had just looked at, that even around in July, the shield building was still delayed. Again, similar set of issues. It says down there, Unit 3. If you go to the next paragraph. And then his last closing sentence kind of sums it up, right? If I honestly believed any of this was possible, I'd stop on the way home and buy a lottery ticket. And I'd only need one, because it's that unlikely that I would be able to do that.
Okay, we need to enter that as well. We haven't entered this as an exhibit. It's number 67.
Thank you very much, Mr. Chairman. Mr. Addison, let's move on to Bechtel. Bechtel was first hired on the project in 2008, isn't that right?
I don't know.
All right. Do you know that they actually worked on the project pretty much at various times, beginning to end?
Actually, I didn't until I heard something earlier this week about it.
And you saw some of the payments that actually you can verify now. SCNG was paid Bechtel both back in 08-09 era and in 2017, right?
I heard that earlier this week. Yes, I did not know that before then.
And it came from SC&G's financial records.
Well, yeah, and I'm not disputing it at all. I just wasn't involved in the construction of the project, so I wasn't aware of it until I heard the exchange here in this room.
Okay, and do you know that before the Bechtel assessment in 2015 criticized SC&G's project management, that Mr. Burns thought and spoke very highly of Bechtel? Did you know that?
I did not.
And he is the nuclear construction guy for SC&G, right?
Well, as we discussed earlier this morning, he was the most senior executive over that line organization.
All right. And in 2008, Mr. Byrne adopted pre-filed testimony, and I'd like to show that now and enter that in the record, Mr. Chairman.
It will be entered in the record as exhibit number 68.
Page 61. Page 61 of Mr. Burns' 2008 pre-filed testimony. And in this, he asked himself, what is SC&G's assessment of Bechtel Corporation and its subcontractors and abilities with regard to the COL application for VC Summer Units 2 and 3? And he answered, I have great confidence. Have you gotten to page 61?
I have.
And let's put it on the board if we can, too, for everyone else. Mr. Byrne answered to this commission that I have great confidence in Bechtel and its subcontractors and their ability to perform as required to assist the company in obtaining the COL. Bechtel is one of the most experienced and well-recognized firms internationally in power systems, construction, engineering, and consulting services. And my colleagues at SC&G and I have extensive knowledge of Bechtel, both from direct working experience and knowledge gained through our long-standing involvement in the nuclear power industry. And in my opinion, Bechtel is exceptionally capable and experienced in work of the kind that it is undertaking for SC&G in preparing the operating license. And you see, and so, and then I think you heard, but even after the Bechtel assessment came out, right, that SC&G got the reports, the SC&G's contractor hired Bechtel for nuclear island work on this project. Isn't that right?
I don't know. I do note here that he says on line 15, work of the kind that it is undertaking. So I presume that's related to the licensing, but right. As I've established, I'm not an expert in it.
Right. And you can't even start the nuclear power plant construction project without the combined operating license, could you?
The nuclear part, correct.
And then, do you remember the payments that came into evidence the other day of over $4 million being paid to Bechtel in early 2017?
I do.
And so Bechtel worked on the project and was paid millions of dollars by SC&G for its work on the project, even after the Bechtel assessment, right?
I believe that's correct.
Okay. In April 2015, did you know that SC&G's management and its board approved the hiring of Bechtel for the assessment?
I've seen that recently, yes.
This is one of Jones's exhibits. You've seen it, at least in this hearing. That the board approved it on April 30th of 2015.
Yes.
And that was prior to the commission hearing in the 2015 docket, wasn't it?
Yes.
Now, do you think it's being completely transparent not to tell the commission about this comprehensive assessment by one of the world's largest and most experienced nuclear power plant engineering firms? Cost $1 million and had been approved by management and the board?
Well, I wish we could have. My understanding, I was not involved in the engagement. I did not see the results of the engagement. Again, I wasn't involved in the project. But my understanding that I've learned is that they were engaged through counsel to help assess the litigation risk, either defensively or offensively, for the owners, and I think both owners. And heard the exchange legally the last few days, and I'm not capable or qualified to go back through all of that. I wish somewhere, and I don't dispute that ORS prepared the audit request correct or not, I don't know, but I wish somewhere along the way that ORS had said, look, we saw somebody with a hard hat, give us the assessment, because I believe the response from the company would have been, it's privileged. And if that had happened, we could have had this whole discussion 3 years ago. And I'll be very clear, I'm not blaming ORS for that. I just said, this is another one of my 2020 hindsights it's occurred this week. I wish that would have been on a document somewhere, because I think the answer would have been the same based on what I understand. But it would have been nice to have that debate a few years ago. But I can't, there are no do-overs, I understand.
And you're just forgetting the part about where Mr. Jones, having heard about this guy with a hard hat out there, putting it on the agenda and asking point blank, SC&G, tell me about the assessment, and being told nothing new, no written report, no reason to even ask the follow-up question of whether it's privileged.
I don't mean to dismiss that. I wasn't there. I didn't hear it. I have no reason to doubt Mr. Jones.
And you weren't here for all of it, but did you remember that there was no privilege objection made by SC&G until these proceedings that had been asked previously?
Until these proceedings, I believe there was one last fall. There was one last summer or fall when this first surfaced.
After abandonment, right?
Yes, sorry.
All right. And did you know that, I mean, we just talked about when the board approved it, but the SC&G agreed to retain Bechtel for that assessment before it ever reached out to Mr. Winnick, the lawyer, to create an attorney-directed vehicle to engage Bechtel?
No, I don't know that. I do think Mr. Winnick's going to be here later in the proceeding, and he can respond to that.
And the lawyer, Winnick, he didn't have authority to spend $1 million of SC&G or ratepayer money on the project, did he?
Again, I don't know. If he was authorized to engage them, I would think he had the authority to spend the money. But I wasn't the one that engaged him. I don't know.
You think without direction from SC&G that the lawyer could have spent $1 million of ratepayer money?
No, I did not mean to imply that. I said if he were engaging them, I suspect he had a discussion with the owners and would have been authorized to pay them for the work that he was engaging them. Mm-hmm. But I don't know that firsthand. I was not in the loop on the process.
But you know that he didn't pay Bechtel, did he?
I don't know that. I mean, I saw what was in the room earlier this week. I don't dispute that, but I don't know it personally.
And you saw earlier, too, that SC&G had been talking with S&T Cooper, even in 2014, about getting an outside consultant like Bechtel to come in and assess the project, right?
I heard the discussion earlier this week. I'm not familiar with it personally.
And did you know that Mr. Byrne was involved in all of that and that he wanted a scheduled assessment done as part of that?
I did not know that. This is Mr. Burns' email on October 31 of 2014. It went to Mr. Marsh and you and Mr. Crosby and Mr. Jones and Archie, and talking about it. He says we've previously discussed it, getting a third party to come look at it, and we're trying to find someone with mega project experience. You remember seeing that? I don't remember it, but I don't know that this is directly tied to Bechtel. I don't know.
In October of 21, it talks about getting a third party to look at our schedule and on-site efficiencies. You know, I mean, obviously this was before Bechtel was the SC&G agreed to hire him in April of 2015, but this is, you don't think that this fits into that, what Bechtel ultimately ended up doing?
Yeah, again, I don't know. I just don't know. I know he references here PricewaterhouseCoopers, and those two are in very different fields. Yeah. So I can't make the leap that he's talking about Bechtel there. I just don't know.
And PricewaterhouseCoopers wouldn't look at the construction schedule, though, would it? Like he was talking about in the first line?
I don't know about that. I mean, these large firms have various consultants. They could have that capability. I don't know.
As Mr. Byrne pointed out, it's a good thing they picked one of the best engineering firms in the world, right, to do the assessment.
I don't know construction. I'm sorry.
Do you know that Bechtel delivered its findings, including a schedule assessment, on October 22nd, 2015, in a meeting with senior executives?
I've understood that post-abandonment.
And were you part of that meeting?
No.
Did you know that Bechtel provided a full final draft report on November 12th of 2015?
I've understood that post-abandonment.
You didn't receive a copy of that?
No.
Were you aware that that Winnick, the lawyer, then tried to black box out everything about the schedule in November? He tried to hide the schedule assessment out of the report.
I was not aware.
Do you know, or have you heard since then, about who instructed him to hide that schedule assessment from the report?
I do not know. If that did occur, I don't know who suggested it.
You know if Bechtel flatly refused to remove the schedule assessment report and instead just made it two separate reports?
I just don't know anything about that consulting project. I was not involved in it. Didn't get a copy of the report. Didn't see a presentation. It wasn't my responsibility, so I wasn't in that loop.
And have you read it since you learned about it?
I have not.
Not the project assessment report or the schedule assessment report or any of the weekly reports attached to it?
I have not.
You just you didn't want to know, or was it hidden from you?
It was not hidden. Once it became public, obviously it was available. It wasn't that I knew I was going to get a lot of questions about this, and I felt like it was most appropriate that I remember what I remembered at the time and not something that I understood later, number one. And number two, I have had a very full plate since that's surfaced last fall. That was, I mean, it's a big issue. I understand how serious it is here. I was not involved in it at the time. I can't change it after the fact. I've tried to focus on the things that are in front of us, which are significant.
Let's talk about it then, just go to the end of this discussion the best we can. Is it when you testified to the commission here on October 13th of 2016, the next year, you didn't know about the assessment, or the completion dates were maybe 2 years into the future. And so that means your testimony really wasn't based on all of the information known to SC&G at the time, was it?
I never saw a copy of that report.
You've now become aware, right, that SC&G has fought to disclose those reports until June 11th of this year, when it made a filing with the PSC and actually filed a copy of one of the reports with the commission?
I'm aware of the assertion of privilege, yes, sir.
And there's no doubt at this point that SC&G didn't provide the reports to ORS or the commission until June 11th of this year.
I believe that's correct.
Let's look at his email from Mr. Bynum. He's one of the attorneys of SC&G, internal.
Right.
And Mr. Byrne, because, we'd like to put to bed the issues that really aren't in dispute. And this seems to be one that is well beyond dispute. But let's just look at what Mr. Bynum, the internal SCE&G attorney, said to Mr. Byrne, who's in charge of nuclear for SCE&G. We'll pass these out and make it an exhibit, hearing exhibit 2, Chairman.
This will be entered as exhibit number 69.
Mr. Addison, you see where Mr. Bynum is making it crystal clear that Mr. Burns trying to talk about what disclosures might be made in November of 2016. And he says, keep in mind that we're talking about the Bechtel report. We never even shared that with the commission. Do you see that?
Where do you find disclosures in here? I may have missed it.
Well, if you look at the second email down, you'll see that there's a discussion going on between Mr. Byrne, Mr. Lindsay, who's another attorney, SC&G, and Mr. Bynum, about the cooperative's request for the nuclear project analysis report, right?
Well, I see that. I just didn't see disclosures.
And he's saying, I realize it would be an inconvenience, but trying to figure out how or whether they're going to disclose the Bechtel report to the cooperatives who are asking about it in November 2016.
Okay.
And the ultimate statement trying to shut down this conversation is Mr. Bynum, who makes it clear in the very top email, keep in mind that we're talking about the Bechtel report. We never even shared that with the commission. You see that?
I do see that.
And you understand the significance of his statement of why it matters that we've never shared that with the commission?
I don't know. I think it's best to address with Mr. Winnick, but again, I'm speculating, so I apologize. But my speculation is that if you share it with one, you have violated that privilege, and you could lose the advantage of it being prepared for an attorney.
And the lawyer Winnick, he wasn't a nuclear power plant engineer, was he?
My understanding, I did not interact with Mr. Winnick very much, but my understanding was he was specialized in legal construction matters.
He's a lawyer.
Construction lawyer, specialist, is my understanding.
And you know now for sure, but probably were aware when you first became aware of the Bechtel report that SC&G's hiding the assessment and these reports delayed ORS and the commission and the public from knowing what SCE&G knew in 2015, don't you?
Well, I would agree that that those parties not having the report prevented them from knowing what's in the report. I don't know I haven't read the report, as we established earlier, and I don't know the credibility of what was in the report related to the schedule, but I think you're going to get your chance to talk to the person that engaged Bechtel, and I suspect you're going to address that with him.
And you know, we also we hear from Mr. Troutman. Have you looked at his deposition and seen his testimony?
I have not.
He's the president of Bechtel Corporation.
I don't know him.
And in fact, SC&G in this proceeding has been very clear, right, that the Bechtel report did not provide SC&G with any new information in late 2015, did it?
Again, I'm not the expert on it. I've not seen the report. I just can't opine on that.
But you know what SC&G's position has been in this proceeding and with respect to the findings and recommendations in the Bechtel report, don't you?
Yes.
And so it's taken the clear position that SC&G did not learn any new information in 2015 from everything that was said in the Bechtel report, right?
I think what I heard Mr. Jones say the other day was that we didn't learn about new issues, and I don't mean just to paraphrase him. Whatever he said, but I think that's what he said.
Mr. Jones is our witness, right? ORS.
Right.
Okay. And so the question is, what does SC&G knew in 2015? And they've been clear in this proceeding. I just want you to confirm it for us that SC&G didn't learn anything new from the Bechtel report in 2015.
I don't know how I confirm something that I haven't read. You can talk to the other witnesses later and see if they can address the matter, or Mr. Winnick can address the matter.
Mr. Winnick's a better witness to address the matter of what SC&G knew in late 2015 about the project than, forgive me, but the current CEO.
With all respect, I haven't read the report. I don't have the expertise to it. He's got more expertise in that industry than I do, and he engaged them. So
You know that SC&G and Santee Cooper mapped out and tracked recommendations out of the Bechtel report?
I don't know that. I heard that earlier this week from Mr. Jones.
And do you know that the schedule assessment done by Bechtel in late 2015 was later verified and corroborated by SC&G's own internal schedule assessment after the bankruptcy of Westinghouse in April of 2017?
Again, I can't. I saw what Mr. Jones, I believe, put up there. I can't tell you that those are comparable. I don't know that.
But the 2017 estimate to completion, right? The schedule assessment done after the bankruptcy, part of that was done in your conference room, wasn't it? The discussions about the schedule assessment, internal schedule assessment after the bankruptcy.
I'm not sure what you mean by in my conference room. What do you mean by that?
There were
remember
meetings in your conference room about the estimate to completion in 2017.
Sure, analyzing the projected cost for the owners to evaluate,
and the schedule too, right?
Sure, that's right. We had to for the owners to make a decision.
And in the off chance that we haven't seen it yet, let's look at that 2017 ETC discussion that was helping SC&G decide what to do in 2017. This is the SC.
Get near that mic when you
Thank you, Mr. Chairman.
hear you worldwide.
You see at the bottom, you recognize that this is part of the discussion that was done. Here's the front page of the ETC on VC Summer by SC&G.
Yes, I see that.
And do you recognize it, that this was part of what y'all were going over in the May of 2017?
I don't remember it specifically, but I have no reason to dispute it.
And in the bottom right, do you see where the estimates for completion dates are actually in this ETC, this estimate completion, is August 2023 and November 2024 for units 2 and 3 respectively.
I see that.
All right. And do you see what the cost, what happened to the cost on the left side, that the owner's ETC here was $6.6 billion at this point, which is a delta of over $2.5 billion more at that point?
I do see that.
And is that what y'all concluded when you did the schedule assessment and estimate and completion in 2017? I
don't remember the specific number, but that sounds reasonable to me, and Mr. Young and Kokums can address that with you.
Okay, and in that 2017 schedule, do you know that SC&G downloaded, just like Bechtel, the same Primavera P6 construction schedule and all the load files to analyze?
I'm not familiar with the details of it, but I know we had access to information that we had not had access to before as the owners.
You know that for a fact, or somebody just told you that?
Somebody told me that. Thank you.
Let's move on to owner's engineer. SC&G never got an owner's engineer to oversee the day-to-day construction management of this process, did they?
Not that I'm aware of.
And in fact, you basically deferred to Mr. Byrne, who resisted this hiring an owner's engineer, didn't he?
Yeah, I don't know that. I just wasn't involved in the construction.
That's pretty high level of how we're going to fix some of these problems that we've been talking about, and Bechtel's recommendation and Santee Cooper's urging, and it was part of the EPC contract. You were never part of the discussions about whether or not to get an owner's engineer?
No, I became involved in the project in the window of the EPC amendment in October of 15, and then dealing with the Westinghouse bankruptcy, where my two primary windows. I am aware that the owners agreed to establish an oversight board and implemented that at some point.
And you remember that was entered into in 2016?
I'm sorry, I don't remember specifically when. Mr.
And-
Young could tell you.
All right. And we'll hear about the differences between an owner's engineer and a construction oversight review board. But did you realize that that SC&G? Let's look at. You want me to put it up or y'all? Let's look at this email. Item to Mr. Marsh on November 29, 2016. It says talking points with Lonnie. Who's Lonnie?
Presumed Lonnie Carter, CEO of Santee Cooper.
All right. And in these talking points, we see where the Construction Oversight Review Board came from. You see that the several points to make. Number one, we agreed to the CORB. That's the Construction Oversight Review Board, isn't it?
I believe so.
In return for flushing the Bechtel report. In fact, Lonnie's email on November 28th arguably acknowledges that the formation was Escana's response to the Bechtel report and Santee Cooper's request for better project management with this large EPC experience. You see, do you know that that's the reason why you got a Construction Oversight Review Board?
No, I don't know the background of that.
You have any reason to dispute that in Kevin Marsh's talking points with Lonnie Carter that Lonnie Carter's email of November 28th made that complaint, and that was the bargain made?
I don't have any reason to dispute it.
Okay. Excuse me. You know that the Construction Oversight Review Board only met 3 times?
Well, I did not know that. I heard discussion of it earlier this week.
Remember, we were talking about that analysis that showed there was another $1 billion if a 12-month delay in the schedule occurred, and that was $1 billion just for SC&G share. Remember, we brought up it was $2 billion, and we talked about how you had to.
I do. Yes.
All right, let's show Brown now. That would have been under the fixed price option. That would have been a tremendous loss to Westinghouse, wouldn't it?
$1 billion?
Yeah, if the real schedule cost another $1 billion just for y'all share, really it's a $2 billion loss for Westinghouse under the fixed price option, right?
For both owners?
Yeah.
I agree with that logic.
So the fixed price option, at least under that particular analysis, that a 12-month delay would have been another $2 billion total, would have fallen on Westinghouse, wouldn't it?
If that occurred, yes. And I think Dr. Lynch testified in 2016 about various scenarios and the evaluation of whether or not to execute the fixed price option.
And did SC&G do anything to assess Westinghouse's financial problems or to guard against a possible bankruptcy?
Yes, SC&G and Santee Cooper had a parental guarantee with their parent. At the time we entered into that amendment in 2015, it was an investment grade rated company with a market capitalization, I believe, in excess of $12 billion.
You're talking about Toshiba, right?
I am.
And that guarantee for SC&G was about $1.6 billion or $1.1 billion.
Well, that's what it turned out to be at the time of the abandonment, but it would change through the life of the project. So it would have been less than that earlier, and if because it was based upon how much had been paid into the project. So if the project had gone longer, it would have been larger.
And the Toshiba parental guarantee wasn't designed to protect the ratepayers from cost increase in the completion of the contract, completion of construction, was it?
Could you say
Sure.
that?
You know how some insurance policies are like replacement costs, so you can
Right.
build your house back if you lose it.
Right.
This parental guarantee didn't come close to providing SC&G with enough money to actually complete construction if Westinghouse and Toshiba didn't complete the project.
Well, in fact, it didn't at the time they abandoned it, and that Westinghouse had represented a number for the cost to complete, and the parental guarantee would have covered that cost. Santee and Scana negotiated extensively with Toshiba and raised that parental guarantee about $500 million. And by the time we completed our own analysis, even that was not enough to cover the cost, which is what led, I believe, to Santee's conclusion.
And it wasn't even designed to cover the cost to complete so that you could actually protect the ratepayers, construct the project, and protect them against the benefits of the fixed price option, was it?
Well, it was designed to put significant capital at risk by the parent in case the subsidiary, Westinghouse, didn't fulfill its obligations, and it did that.
Didn't do it completely, did it?
It did not result in the project being completed. No question.
And you knew that Santee Cooper was raising with SC&G liquidity concerns about Westinghouse in 2015 before you even got to the EPC amendment, didn't you?
Well, I think Westinghouse was constantly challenging the project owners around invoicing and liquidity, so I don't think that was a new information to anyone.
You knew about those problems, and did you know about Toshiba's accounting?
I don't know about problems. I mean, the construction industry is constantly challenging their customers. Has been our experience to try to bill as aggressively as they can.
And you knew that Toshiba, the Westinghouse's parent, had accounting scandal, and its credit rating had been severely downgraded.
And I believe in 2015 they disclosed accounting issues that allegedly were not related to this division at all. And as you see in my pre-filed testimony, there's a chart in there that shows that their page 34, that their stock price had recovered completely from that in late 2016 when we were here in front of the commission to evaluate the fixed price option.
And then we all learned it was a lot worse, and they actually, within 3 months of that period, that December earnings failure to disclose earnings, right, that they put Westinghouse in bankruptcy, right?
I agree with that.
And then the EPC amendment was finalized in late 2015. Part of that, SC&G agreed to make 5 monthly payments to Westinghouse of $100 million a month until this construction milestone payment schedule was set up, right?
I agree, but that's the total group of the owners. SC&G's was $55 million.
Thank you. So the total payments to Westinghouse was $100 million a month for the first 5 months of 2016.
That's my recollection, yes.
But SC&G ended up making 8 payments of at least $100 million in 2016, didn't they?
I think those interim payments were, and Mr. Kokums can give you more details on this, but I think those interim payments were to provide a time period so that a milestone payment schedule could be developed. And it was not completed by the 5 months, so it was extended, I believe, is what occurred.
These payments were made, as you said, because it wasn't set, but the Westinghouse just wouldn't keep working unless they had these large cash payments, right?
Sorry, I just don't know the answer to that.
And the consortium wasn't actually doing, billing for work here. They were giving y'all what y'all called internally phantom invoices in order to make these payments. Isn't that right?
And Mr. Kokums would need to address that with you.
And were you aware that in July 13th of 2016 that Lonnie Carter complained to Kevin Marsh about these payments and that the construction progress had only been like 3% during this 6-month period total?
I don't recall that.
Did you know that ORS asked about these additional payments because Westinghouse was having financial problems and was told that SC&G didn't believe there were any financial problems.
I'm sorry, I don't believe I was aware of that either.
In fact, SC&G had already heard at this point in time, right, in 2016, March or May, that Santee Cooper wanted the project to get bankruptcy counsel because they wanted to analyze the risk about Westinghouse and Toshiba filing for bankruptcy. You knew that?
I can't tie a specific date to it, but I do recall some discussion along those lines.
We look at that March 21 board meeting minute. You remember a joint board meeting of the owners at the Columbia Hilton on March 21st, 2016?
I remember a meeting. I just can't tell you exactly the date.
Right.
I have no reason to believe that wasn't the date.
All right, this is an excerpt from one of the Warner exhibits outlining the bankruptcy issue timeline for Lonnie Carter. You remember that when there was a joint board there discussing the declining financial condition of Toshiba and the financial response of the owners, that they met with that lawyer, again, Lawyer Winnick, and requested bankruptcy counsel be retained for the project?
I do remember that discussion.
And that it would actually be a proactive measure given the Toshiba's and potentially Westinghouse's financial condition at this time in March of 2016.
Right, and again, I'd refer back to that chart in my testimony on page 34. I think that is related to the accounting issues that were in a different division, and then the parent recovered from that later.
And the EPC amendment in 2015, and particularly the fixed price option, made Westinghouse's creditworthiness a significant risk to the project, didn't it?
I'm sorry, the EPC amendment made it a significant risk?
Well, more specifically, the fixed price option made Westinghouse's creditworthiness a significant risk to the project.
The amendment itself? Or the execution of the fixed price option?
Right, because you're pushing that $2 billion or maybe more onto Westinghouse with a fixed price option, right?
Well, I agree with you. The intention was to move the risk from the owners and their customers to Westinghouse. At that time, you'll recall, 2/3 of the contract was already fixed. Allegedly, the Vogel project was already fixed. So 1 2/3 of the two projects, Vogel and Summer, were already fixed. I'm not sure the other third created a significant additional risk, but I grant you it was some additional risk, which was our intention, was to put the risk on their back, not on the customers of the two companies.
And because of your shifting additional risks of substantial material numbers on this project, the Westinghouse, its creditworthiness and ability for it to perform under the contract was a risk to the project because of the fixed price option. Isn't that right?
I think the risk to Westinghouse on the project was because the parent chose not to continue to fund the project. What was represented to us in August of 16, us being the company and several interveners here, including ORS, was that Westinghouse was banking on these sales of these units worldwide. And if not directly, the implication was that they were likely to lose money on these in the U.S., but that it was critical to complete these to be able to sell the others around the world. I think what ultimately happened is the parent said they're not going to put the capital in there to finish these.
And we've seen that it was billions of dollars that they were having to infuse into finishing this project. And SC&G knew that, didn't they?
Billions? No, I believe, and Dr. Lynch needs to address this appropriately, but when he's here, but I believe his analysis in 16 said it could be several hundred million up to $1 billion for SC&G, if my memory is correct.
And given the 2017 ETC and those conclusions just a year later, He's wrong about that. It was $2.5 billion, wasn't it?
You just need to take that up with Dr. Lynch, I believe, his work.
And it was your work, partially in your conference room, that SC&G determined that it was $2.5 billion more to finish the project in May of 2017. Isn't that right?
That was the work of the combined team, yes, including, I would say, working with those at the Vogel project to share information.
And the EPC amendment that was negotiated but wasn't signed until that Bechtel assessment on October 22nd was presented to senior management. Isn't that right?
Sorry, repeat that now.
And the EPC amendment that gave the fixed price option, it was negotiated, but it wasn't signed until after the October 22nd, 2015 presentation of Bechtel, their findings, to the SC&G senior leadership.
Right, it was executed on October 27th, is my memory.
And SC&G knew that Westinghouse could use bankruptcy to get out of the EPC contract, didn't they?
Yes, in theory, if bankruptcy is available to anyone that operates in the U.S.
Yeah. And you know that's true, too, that they can get out of a contract, even a fixed price option contract, if they file bankruptcy.
If they elect to go that route, it could be invalidated, and it was. I don't think that was the expectation of anyone, including Westinghouse at that point.
Let's look at the 2016 settlement agreement then. Saying it wasn't in contemplation of anybody. When SC&G wanted approval in 2016, they were asking for approval of a $300 million more in the budget. And this price, there was a cost to exercising the fixed price option, right? It was $500 million.
That sounds correct.
Okay. And the fixed price option actually put Westinghouse on the hook for all the additional cost of the project, over and above that $800 million more that was requested in 2016.
Essentially, yes.
And SC&G actually agreed to guarantee for the ratepayers the benefits of that fixed price option, even if Westinghouse didn't complete the project, didn't they?
I don't believe so.
Do you remember, or are you part of the 2016 settlement agreement in the proceedings for the approval of this fixed price option?
I was part of those proceedings.
Let's look at paragraph 12 of that agreement. See where it starts? SC&G therefore agrees. Excuse me. Let's go to the line right above that. I want to see that. Thank you. The settling parties agree. This is from the 2016 settlement agreement with ORS, and I believe some of the interveners. The settling parties agree that the payment for the option will not be contested, provided that SC&G takes certain steps to ensure that the ratepayers retain the benefit of the fixed price. SC&G therefore agrees to fix the price to consumers for EPC contract costs according to the terms of this settlement. And at that time, the EPC contract costs were like 97%, right? All that was left was owner's costs.
I believe that's correct.
Okay. And let's go down, if we haven't already looked away. To this effect, SC&G agrees it will not file any future requests with the Commission seeking any additional or updated budget increases related to construction of Units 2 and 3 unless they're related to signed change orders, transmission costs, time and materials specifically outlined in a paragraph, page 1, that relates to sales tax, performance bond premiums, import duties, and mandatory spare parts and extended warranty. That's actually a pretty limited exclusion, right, to this guarantee of the fixed price option for customers, isn't it?
Well, I think we felt like as owners that the consortium was taking responsibility for the majority of the cost to complete the project.
And ORS insisted on this guarantee from SC&G in 2016 because it didn't fully trust that Westinghouse could shoulder those losses if they didn't complete the project.
My recollection of it was that ORS wanted to, and I believe other interveners wanted to ensure that we weren't back in front of the commission again with a cost increase we had just been in 15, and we discussed earlier, and this was again in 16 to execute this option. And so I believe, that's not shown here, but I believe this continues on to say if there is another increase, it has to be deferred for a few years until the first unit comes online or something like that.
And you can see from this language, it's intended for the benefits, to protect the benefits of the fixed price option to the customers, right, to the ratepayers.
Right.
And SC&G didn't live up to that protection for the ratepayers, did they?
The consortium did not live up, or the Westinghouse did not live up to its contract. It filed bankruptcy and invalidated.
And this doesn't say anything about the consortium, does it?
I don't see anything about it there.
They're not a party to the settlement agreement or to the proceeding at all, were they?
No.
SC&G didn't protect the ratepayers with the fixed price option or finish the construction, did they?
No, because it was not economically viable for the customers.
So basically 9 years here at this point, 9 years into the project, when SC&G has acknowledged for the first time that it might be responsible itself for the construction of the project. This is in 2017 after bankruptcy, right? Westinghouse isn't gonna live up to its part of the bargain. And here it's faced with the guarantee from the settlement agreement that it's got to live, and it's on the hook for the cost negotiated with the fixed price option. That's the first time that SC&G decides it better do a comprehensive schedule assessment and estimate to completion. Isn't that right?
I think it's the first time that the owners had access to the information to be able to do it.
It just asked for it, right? Didn't it?
Sorry?
And the owner just asked for the information, didn't it?
Right, but this is post-bankruptcy where they're, if not required, are much more amenable to provide the information where they would not before. It's my understanding, but Mr. Young and Mr. Kokums can give you more information on that.
When that analysis was done, SC&G was able to confirm that the dates for substantial completion of the project were out at least as far as Bechtel had concluded, and that the costs were almost $2.5 billion more. Isn't that right?
I believe that's correct.
And then the abandonment of the project saved SC&G from the consequences of this 2016 guarantee to ratepayers, didn't it?
Not sure I understand your...
Well, when faced with having to live up to the fixed price option and the guarantee that it had made to the ratepayers in the 2016 settlement agreement and to this commission, SC&G decided to abandon the project and not bear that burden rather than continue. Isn't that right?
SC&G was still evaluating whether or not to continue when we lost our partner.
Yeah, we've heard SC&G blame Santee Cooper.
I'm not blaming them. I'm just giving you a fact. In fact, I said to Mr. Carter, if our positions were reversed, I understand how we both come to our conclusions. But it had a devastating impact on the project going forward.
And didn't Santee Cooper see the same estimate to completion and the $2.5 billion additional cost of the project, the years into the future, the loss of the production tax credits? Didn't it see the same information that SC&G determined in that estimate completion we looked at?
They did see the same information. As it relates to tax credits, our advisors have been telling us for quite a time that they felt like that those deadlines would be removed and also that public power would qualify for those, and that eventually happened. Unfortunately, it was post-abandonment. Those deadlines turned out not to be an issue with tax credits.
But at the time, though, you're telling this commission that when you finally turned and looked and did a true schedule analysis in 2017 and found out it was going to be 3 and 4 years later than you'd ever told the commission and $2.5 billion more, that was it was Santee Cooper's pulling out that made the difference to SC&G.
That stopped the analysis. It was not possible for us to go forward on our own.
Did you know that Santee Cooper actually didn't even believe y'all's numbers? That they thought that the numbers, both the cost to complete and the schedule, were much worse than what y'all had concluded?
I heard Mr. Crosby express his skepticism.
We saw Mr. Brown's analysis back in 2015 about it maybe taking as many as 26 years to complete at the current process.
We did. Those are at two different points in time, and I find that difficult to believe, given that there's one operator, or maybe two operating today in China.
China's a different regulatory environment and safety standards too, right?
No question.
The government's involved over there building the project, right?
I agree. I'm not sure it makes 26 years difference.
Why didn't SC&G come to the commission, for example, through an allowable ex parte or something, to talk about considering abandoning the units prior to the actual abandonment?
I believe we did. I believe we came in at the time. I'm not positive about this, but I believe we came in about the time that Westinghouse declared bankruptcy and discussed that we're evaluating all options, completing 2 plants, completing 1, or abandoning them both. I may be wrong, but I believe that's the case.
I wanted to turn to your rebuttal testimony. It was short, but it had a few things in there that were confusing to me. In the top of page 2, you talk about the BLR, the owners of the project, being liable for imprudent actions of contractors and consultants. Do you believe that the owners can contract away that responsibility? Statutory responsibility to be prudent in this project?
I don't believe the owners can contract away the responsibility to be prudent in the project. I think the owners had the responsibility that the commission ordered in their original order in 2008.
And part of which was based on your testimony that you'd be completely transparent.
I agree. And the oversight, et cetera, that we reviewed earlier this morning.
And then in the middle of page 2, you talk about the BLRA was enacted, offered investors critically important protections against retroactive prudency reviews and disallowances. That seems to imply that maybe the abandonment process here can't do a prudency review or disallow costs, but you don't intend that to extend to this abandonment proceeding, do you?
As I testified to in the direct testimony, certainly the prudency of the abandonment is before the commission today.
And then you end this rebuttal testimony with an interesting statement. You said SC&G would not have entered into the EPC contract with the uncertainty and financial risk if the standards that we've been instructed to apply in this abandonment proceeding had applied in 2008. And I'm just curious, does that mean that SC&G would not have done the project?
I don't believe it would have been financeable had the same constraints been in place originally that were put in place by the Act. Investors would have perceived that you could look back and change decisions that were embraced along the way. I don't know that we could have raised the capital.
I mean, wasn't that a risk that fell on SC&G and not on the investors of having the ultimate responsibility for the project?
I mean, they're the same. SC&G is investors are backing SC&G. Unless I missed your point.
Well, I mean, prudency, we know it's a high standard, right? Y'all, Mr. Marsh testified about that in front of the commission. It's always been a high standard because of the high risk to ratepayers and to investors, right? So it's a high standard for prudency, due care, and diligence
I mean,
from the very beginning, right?
prudency to me is what would a reasonable person, in this case an entity, do based on the facts and circumstances they have at the time. I mean, I believe that's a reasonable definition of it.
But not the same as you know, I've got to be reasonable person and prudent when I walk down the aisle leaving, that I don't hit somebody in the head, right? I mean this is a nuclear power plant construction project that had $5 billion being placed at on the shoulders of the ratepayers, even after the financing costs, right? So
I agree with you. It's a significant responsibility.
And the additional definitions that have been passed, that doesn't change the prudency standard. It just further defines it, doesn't it?
I think we need to disagree on that one.
Okay. The EPC contract, the amendment in 2015, that resolved all the commercial disputes, didn't it, with the consortium at the time?
I believe it resolved all the significant differences. I can't say absolutely, but Mr. Kokums could tell you, but I believe it resolved all of any significant.
Let's talk just a second about merger conditions, and then we'll just finish up with talking briefly about the rate plans. Okay. The applicants have outlined the commitments in its narrative portion of the application, in exhibits to the application, in some of the direct testimony, and also in response to some of the ORS testimony. The ORS discovery requests. Do you know that?
I'm sorry. Repeat that again.
Sure. I mean, one of our problems is that some of the conditions made by the joint applicants are spread out over the joint application, the exhibits to the application, the direct testimonies, and in response to ORS discovery requests in this case. Okay. Did you know that?
I did not.
All right. And they didn't really y'all haven't provided a comprehensive list of merger commitments in a single document or exhibit yet to the commission.
I'm sorry, I was not aware of that.
You remember that Lane, Mr. Collin, did put all of those together, not just for the applicants in his direct exhibit 25, but also from ORS in his exhibit 26. And then more helpfully, when Commissioner Irvin was asking him in his, I think, surrebuttal testimony, exhibit 8 as a comprehensive list of. Have you looked through those and gone through those merger conditions?
I have not. I believe that's an issue for Dominion.
Okay. All right. Well, let's because there's at least some question about whether that is a foregone conclusion or not. Let's talk about SC&G's commitments. In the merger benefit plan, this is, let's leave the merger conditions to others.
Okay.
How about in the base rate case or in the no merger benefits plan by SC&G? What SC&G is promising to the ratepayers and to the commission that they will freeze retail electric base rates at current levels until January 1, 2021. That's in the application at 57H. Does that sound right?
I think it's also in my testimony.
It might be there too.
Let me find that, sir. But yes, I agree with that.
All right, and also the new generating facility is the Columbia Energy Center.
Yes, sir.
In May of this year, y'all closed on $180 million natural gas fired power plant in Gaston.
Yes.
And SC&G is committing to the ratepayers and the commission that it will be excluded from rate base and rate recovery, except in total and forever, except for the fuel costs and operations and maintenance expenses and maintenance or improvements associated with the plant. Right?
That's correct. The plant was purchased with investor money, no cost to the customers, but the operation and maintenance of it we would need recovery of.
All right, and there's maybe some others too, but let's just deal with one last set of them, is on credit quality, because the return on equity has been an issue in this case, and we haven't been able to get agreement for the commission, and we'll hear more about that tomorrow. But SC&G return on equity should be determined using a group of would you be willing to agree that they would use a proxy group of investment grade regulated utilities?
You need. We got experts that are going to testify on that matter, and I would really prefer you to discuss that with those experts, Mr. Hebert and others.
All right, we can do that. Let me ask: is SC&G right now, or really South Carolina in general right now, is facing some of the largest and highest utility rates in the country? Isn't that right?
Our rates, well, not after the decrease, not after the temporary decrease. No, our rates were higher prior to the Act 258.
So before the experimental rate, SC&G's rates were really the highest in the state.
I don't know that, but I don't dispute that at all. So
in any event, they were substantially higher than Duke Energy and Duke Progress, right?
Yes, I believe so.
And so let's look just briefly. Can I get the Elmo, please? Let's look at the rate plans. Are you familiar with the cost recovery under the experimental rate? The total N&D cost recovery, about $78 million a year. You know that?
The balance after the impact of the reduction. Is that what we're talking about?
That's right. What's being collected by SC&G right now under the experimental rate on an annualized basis?
Don't know.
But roughly, we know it's the experimental rate decreases by about $367 million, and the total authorized was $445.
That's right.
And the difference there is in the ballpark of $78 million.
That sounds reasonable.
Do you remember Mr. Collin testifying about the ORS plan for the levelized annual N&D cost recovery for the ORS plan being $85 or really $86 million a year?
I remember that.
Okay. So you can't dispute that the ORS plan on N&D recovery actually gives more revenue to SC&G than what the current experimental rates do.
I can't agree to that. I don't understand all the components of his rate plan, so I can't agree to that.
All right. Well, this is just one component of the rate plan, right? So this isn't what the rates, the average monthly rate for a typical residential ratepayer would be. This is the component which is the N&D cost recovery over 20 years, and it's given at a levelized basis. And so the other components that we'll talk about in just a second are Tax Cut Jobs Act, for example, other potential merger savings, tax savings. But if you're just looking at the new nuclear development cost recovery, which is what the experimental rate does, right? It doesn't deal with these other Tax Cut Jobs Act savings issues. It says this is what you recover for revised rates to finance the new nuclear cost alone, right?
Yeah, and if we're going to get into the detail of the rates, I think it'd be more productive to have you talk with Dominion about their rate proposal or Mr. Rooks about SC&G's rates.
Can you tell us and confirm for us that SC&G, as part of the joint application and in part of its filings and other dockets, has asked the Commission to decide to decide and to put into rates in this proceeding the Tax Cut Jobs Act savings that are really unrelated to the nuclear project altogether?
I believe that the joint applicants have requested that.
And so these savings and those components of the ORS plan, for example, that Mr. Colin was talking about are non-NND tax savings and don't have anything to do with the nuclear recovery, right?
They're absolutely tax savings unrelated to new nuclear, yes.
And so they're only in this case because SC&G and the joint applicants have asked for that, right?
Yes.
Okay, so if you include those into plan comparisons, it particularly with the experimental rate, when the tax savings haven't become part of the rates yet, it's a little misleading, isn't it, to compare rates, the NND recovery with unrelated tax savings, isn't it?
Well, I do think they're unrelated. I'll agree that.
And even SC&G actually has two rate plans in this filing. One is the no merger benefits plan, and the other they call the base case or base rate plan, which is kind of a full recovery.
That's correct, and we don't prefer to implement either one of those. We prefer, obviously, to implement one of the Dominion plans, which is much more customer friendly.
But suppose we don't have the opportunity for a merger. You submitted the base rate plan really just for illustrative purposes, right? I mean, it's not something that SC&G is actually advocating that this commission should decide between the no merger benefits plan and the base rate plan. It's really just offering the no merger benefits plan if it's sitting here alone, right?
They're presented in the order of our preference and in the order of customer friendliness, I would say. And obviously you want the merger, and I think are contractually required at this point to be for the merger, obviously. But you know that SC&G can survive on the experimental rate recovery for NND, don't you? Survive? I can't say the entity won't survive. What I don't know is what's the cost going to be.
Fair enough, because we'll hear some discussion tomorrow about the what level of access to capital markets, and it's really just a matter of at what cost, right? Even if you're in the speculative territory, you still can borrow money. It just costs more.
That's usually true. It's not always true. I'll tell you, in the last financial crisis, the markets were shut down to a lot of that group.
Speaking of tomorrow, that's when we're going to take this back up.
Final question.
Final question? You swear?
Well, it's the only one written.
Okay.
Depends on his answer.
Final question.
You were the CFO, obviously, of the company, making disclosures to SEC and obtaining financing, and no one told you that one of the most reputable nuclear construction companies in the world, according to Steve Byrne, had determined that the schedule for a multi-billion-dollar construction project, bet the company project here, was off by almost 2 years, did they?
No, I don't recall anyone telling me that. And, of course, those folks aren't here anymore, as we established earlier, but I'm only left to conclude that they didn't feel the information was reliable. I think we're best to take that up with the witness that's going to speak on back to Mr. Winnick.
Mr. Chairman, thank you very much. No further questions.
Thank you. All right, we've come to the end of the day, and we will see everyone here. Yes, sir.
All possible. Tomorrow morning, we've got a couple of witnesses. Tomorrow, we have a couple of witnesses, day certain. Will we take them up at 9, or will we carry on with cross-examination, Mr. Addison? Or are you in a position to say?
Mr. Chairman?
We're going to probably.
Yes, sir. We would prefer to have Mr. Addison's testimony completed, and our witnesses will be standing by and ready to go, our other two, upon completion of the cross-examination.
Yeah, that's probably, Mr. Butler says that's normally what we'll do, so I think that's the way we'll go with it.
Any answer would have done. Thank you very much.
Then that's it. Thank you.